Josh Swanson, Vogel Law Firm.
And joining us today, Mr. Josh Swanson, Vogel Law Firm, and we're kind of following this mineral rights case in North Dakota. And a decision has been made, so we'll let the good attorney talk to us about kind of what the decision was and whether your landowner, mineral owners, are happy or dissatisfied.
Well, it's the great Yogi Berra used to say, Jason, it's deja vu all over again. The Industrial Commission adopted an order last Thursday regarding the ordinary high water mark of the historic Missouri River, and as it relates to the mineral owners, some of them, including a handful of my clients, came out on the good side of it, the correct side legally, where the Industrial Commission recognized that the high water mark was the takings line established by the United States Army Corps of Engineers in the 1950s when they acquired all that property for Garrison Dam and Lake Sakakawea. But somehow, how they got there, they decided that the state would claim 10,000 acres they have no right to claim, they have no interest in, they're a stranger to title to those acres. But the Wenck study came out and said those acres are now below the ordinary high water mark when the United States Army Corps of Engineers back in the 1950s decided they were above the high water mark and the minerals would be retained by the owners whose property the United States acquired for the Garrison project. So really it's as simple as this, Jason. The state of North Dakota has decided that after those 10,000 acres, the United States can flood those acres and acquire it for the Garrison project, and the state, not the private mineral owners, owns those minerals, which is a blatant taking under the Fifth Amendment of the United States Constitution and also under the North Dakota Constitution. It is the exact same problem we had that was litigated in the Wilkinson case, which was decided by the Supreme Court, and apparently the attorneys working for the Industrial Commission didn't bother picking up a copy of the Wilkinson decision or the United States or North Dakota Constitution to take a look at the takings implication of the order that they adopted.
So this wasn't a court case. This was the Industrial Commission's vote on whether the state would get the mineral rights or not. Is that right?
More or less what happened was this. So back when the legislative session met in 2017, there was Senate Bill 2134, which I know you've covered it extensively and you and I talked about it, and that was a bill that established or said, okay, here's what needs to be done to figure out what the ordinary high water mark line is with regards to the historic Missouri River. Now, what it says in that legislation, which was ultimately codified at Chapter 61-33.1 of the Century Code, was the Army Corps of Engineers line is the presumptive line. Now, the reason they set the Army Corps line as the presumptive line is because the Army Corps of Engineers was in the best position back in the 1950s to determine where the high water mark was in the 1950s. Now, there's a March 2016 decision by the Department of Interior that lays all this out in great deal, telling the state of North Dakota, you cannot go in there, state, and decide to change the high water mark of your own volition of the historic Missouri River and say it's something else other than what the United States Corps of Engineers said it was. Well, that's exactly what the Industrial Commission did in adopting this order. The statute said that the state had to hire some surveyors to figure out what the ordinary high water mark line was. What I said at the time during the legislative session was the same poison pill that the legislators were putting in the bill calling for another study has the same problems as the Bartlett and West study that led to the legislation in the first place. Now, I've seen the article in the Williston Herald where there's folks that supported the bill that came out and said, well, we had to do this for certainty because of the Reef decision in 2013. That's horse crap. There's nothing about the Reef decision that required the Industrial Commission to adopt the Wenck Associates line or had anything to do with the legislation. The Bartlett and West study was done 5 years before the decision in the Reef case was issued in 2013, and that dealt with an entirely different subject, the shore zone, which is the area between the ordinary high water mark and the ordinary low water mark. And so the NDIC is trying to muddy the waters, so to speak, by trying to interject the Reef decision into it. The only case that is relevant to what they did is the Wilkinson case and the court cases cited in that decision that says if the state claims these minerals, that is an unconstitutional taking. The state cannot go back and take minerals that have been owned by private. This is the key, Jason. This is the key. What the state is doing with these 10,000 acres that they're now claiming that they've never had a right to, they are going back more than 60 years and telling these mineral owners that we don't care that you reserve these minerals when the United States acquired your property for Lake Sakakawea. We do not care that you've been leasing these minerals for the last 60 years. We do not care that the state never had a claim to these in the last 60 years. And we don't give a flip that the United States Army Corps of Engineers determined that this is where the ordinary high water mark line was. The state threw all that out, and they're relying on a survey done by an out-of-state firm to say where the historic Missouri River line is some 60 years ago in present day, which is utterly absurd, and it's opened the door for more lawsuits, for constitutional challenge, and the certainty that they've purported to be pushing for going back to the last session is totally out the door. And the frustrating part about all of this, Jason, is they saw this coming. They had an opportunity to correct it. They had an opportunity to say, no, we're going to recognize that these private mineral owners have owned these minerals for the last 60 years. We're not going to take them, but instead they're relying on this Wenck survey to do exactly that.
The survey company, is that Wenck?
Wenck Associates, correct.
Are they, what's their story? I mean, you say they're out of state, but they're pretty active out in the Bakken. I mean, are they getting government contracts, or what's the story there?
Well, they got their government contract, and it was a pretty big one, and they got paid hundreds of thousands of dollars to invite more litigation against the state of North Dakota. And I think really all you need to know about this Wenck Associates survey, go back to the June 2018 public hearing that the Industrial Commission did at the State Heritage Center in Bismarck. There were over 1,500 pages of public comments submitted. Everyone from myself to the Petroleum Council to the North Dakota Professional Land Surveyors. There were a lot of groups that came out and panned that study, pointing out the many flaws in its methodology and how it went about its business. There was not a single comment that said, yep, they got this right. And so what did the Industrial Commission do in light of those 1,500 some pages of comments, pointing out to them, hey, here are the serious flaws with the studies, including the unconstitutional taking that it's sanctioning. Well, the Industrial Commission went back and they didn't do a darn thing. They more or less adopted the survey as is, and here we are. And we're staring down the exact same problems that we've been arguing about and facing for the last 5 years here.
I think there should be a special committee to oversee some of these engineering firms, man. They get such plush government contracts. I don't know how the conflict of interest hasn't been in more public discourse. I mean, am I out of line for saying that?
Yeah, and I think, Jason, that there are a lot of folks in the state legislature that tried to do right by this. And I don't want to come across as signaling them out and damning them, because there are a lot of them that put a lot of time and thought and work into the bill. The problem was you had folks from different state agencies and certain legislators that were insisting that a new survey be done. There was no need to do a new survey. The ordinary high water mark line that has been the basis for oil and gas companies that have been leasing minerals the last 60 years based on the ordinary high water mark line set by the Army Corps of Engineers when they acquired property for Lake Sakakawea. Now, if you think about that, that makes pretty good sense. The United States government just didn't go out there willy-nilly in the 1950s and arbitrarily pick a line and say, okay, here's the property we're going to take and acquire, and here's where the lake's going to be. They put in many, many different factors, including an on-the-ground investigation to determine where that line would be for the property they were going to take. Well, if you think about it, what's one thing that these engineering firms can't do nowadays in 2017 and 2018? They can't do an on-the-ground survey because the historic Missouri River is underneath Lake Sakakawea. So there is not a single shred of scientific evidence or a good basis for Wenck Associates to say that, no, what the Army Corps of Engineers decided was wrong, where the historic river existed in the 1950s, even though the Corps was out there on the ground making that determination in the 1950s. Somehow Wenck Associates is saying 60 years after the fact removed, they're in a better position than the United States was to determine where that line was. And the key part of it is the United States took that property either through sale or condemnation from the private owners. So the private owners had one of two options. The United States said you could sell us your property, and if you don't sell it to us, we're going to get it condemned. And there are many, many condemnation orders from the United States District Court of North Dakota where the court ordered property condemned. And that was the property taken for Sakakawea. That was the property taken for the Garrison project. You can't go back and reinvent that wheel like the state's trying to do there. And that's the big problem, and that's what was addressed in part in Wilkinson. So to the extent that the Wenck survey, now by and large, Jason, and for the majority of property there, the Wenck survey follows the line set by the United States Army Corps of Engineers. But inexplicably, for about 10,000 of those acres, they deviate from it and give 10,000 more acres to the state. And as someone that covers the Bakken probably better than anybody else out there, Jason, you know how valuable 10,000 mineral acres are. And we're talking many, many millions of dollars that private landowners stand to lose based on what the state did. And the maddening part for me, you know, I'm an attorney. I work at a private law firm. We get paid a lot of money to represent our clients. And in a situation like this, it's frustrating that having fought it for other clients and taken it this far and gotten the decision in the Wilkinson case, there's now going to be a whole other set of people that are going to have to fight the state about this in court. And with all due respect to Lynn Helms, you know, I have no personal beef against Mr. Helms. He and I have talked on many, many occasions. I think he's competent. You know, I think he's done a very good job in his job, in what his job and his role is. But here's the problem that I have with what he's saying in the papers this week. He's saying there's, well, a 2-year gap. There's 2 years to bring lawsuits, and it'll be decided in 2 years. Well, you have to file the lawsuit in 2 years, and lawsuits are also expensive. I've had several clients pay me many hundreds of thousands of dollars to fight the state on this, and so now the Hobbesian choice that other mineral owners have is lay down and let it go, and see their mineral owners go down, or mineral acres go down the drain, or they hire someone like me and pay me a bunch of money to fight for something that's already theirs. And now we've got to relitigate it, and when this is over, is the state going to reimburse those mineral owners, fighting them once they prevail in court? Because I really feel that private mineral owners will prevail on a constitutional challenge, but after they've spent, let's say, $400,000 or $500,000 hiring an attorney to fight this, is the state going to go back and say, yep, we goofed on this order, we goofed on the methodology, Swanson was out there kicking us in the pants, telling us we screwed up. There are many, many other people at the public comment hearing kicking us in the pants, telling us we screwed up. We did it anyway, and now the court said we were wrong, so, you know, no hard feelings, mineral owners, and share your mineral acres back. And are they going to write a check to those folks for the hundreds of thousands of dollars in attorney fees they're about to incur? Well, if you're buying that, I've got a bunch of ice to sell you in mid-January.
I tell you, some of this stuff just doesn't pass the smell test, and it seems like a very common behavior that I've seen more and more throughout the state, where they'll take a Wenck and company, or a company like that really gets quite a bit of government contracts. And again, I go back to, there's got to be something that oversees that, because you're not going to bite the hand that feeds you. And you know what I mean by that? And it just seems like that it's almost like people get insulted by just making that observation nowadays, whereas, you know, 10, 20 years ago, you tried your hardest to avoid it. Now it just seems like it's quid pro quo.
And what it's not a complicated issue, and that's one of the, if you hear anyone in state government, if you hear anyone running for office saying, this is a very complex issue, this is a very complicated and nuanced issue, that is not the truth. There's nothing complex or complicated about the government saying, we can flood your property, and as a result of flooding that property, we can take your minerals. That's as simple as it is. It's not any more complicated or complex than that. The government came in the 1950s, acquired a bunch of land for Sakakawea, then they flooded the land for Lake Sakakawea. What the state of North Dakota is now saying for about 10,000 of those acres is, yeah, we know they were acquired by the United States. Yeah, we know they were flooded by the lake, but somehow we, the state, now we own those oil and gas rights. Too bad, so sad, mineral owners. That's really as simple as it is. You don't need to be an Alan Dershowitz, Ruth Bader Ginsburg, Neil Gorsuch, and Antonin Scalia. You don't need to be a constitutional scholar to understand that that does not pass the sniff test for the Fifth Amendment of the United States Constitution. And in North Dakota, those property rights, the reason I'm so fired up and upset about this case is I'm a fifth-generation farm and ranch kid. My great-great-great-grandparents, they came over from Europe around the turn of the century. They homesteaded up by Maddock and Esmond, North Dakota. My grandpa and dad, they farmed the same farmland that my grandpa's grandpa and my dad's great-great-grandpa farmed when they were growing up. That land's been in our family for 100 years. And it's not a lot of land, but it's a point of pride. It's part of our legacy. It's part of our heritage, knowing that the folks who came before us, our family members, put down those roots and fought like hell to make a living in North Dakota and build this great state up to what it is. Now you have this, and many other landowners did that across the state, and those are the folks that are impacted by this decision from the Industrial Commission. And to tell them they have to now spend hundreds of thousands of dollars and fight a fight that could take 2 more years and cause more heartache and more hassle, what they ignore is the fact that, outside of the cost to it, I have clients that have literally died during this litigation waiting for a result. They still don't have their money despite the fact the NDIC, part of their order, recognized that, okay, yeah, the state doesn't have a claim to their minerals. They still don't have their money, and several have died during the litigation. So for folks in the state government to say, well, 2 years isn't a lot of time, well, I would invite those folks to pay the legal bills for my clients who now have to fight the state on it, on something that is just such common sense, and how the state screwed this up again, Jason, how the state got this wrong again. And we'll fight it out in court. That's what they want to do. They want a constitutional challenge. I'm proud to represent those folks. I'll be proud to file a lawsuit on their behalf, and I'll be proud to haul the state into court on it again. We've done it before. We'll do it again, and they teed it up for us. So let's play ball.
And just to be clear, this flooding, that was done by the state. This isn't a Devil's Lake thing where it's just for some reason the lake's coming back and a bunch of people's land are getting flooded by a natural cause. This was the state that flooded it, right?
So with regards to Lake Sakakawea, it was the federal government, the United States, came in, and that's an issue in and of itself that ties into this. The state of North Dakota is a stranger to title, and you know how it works. If you own property, take a look at an abstract. There are deeds going back and conveyances years and years and years, in some cases more than 100 years for any tract of property. So the state of North Dakota has never had any sort of claim to the title to this property. They're strangers to title, and now they're claiming that by virtue of the United States flooding it for Lake Sakakawea, that somehow they as a state in 2018, 60 years after the fact, after the land was acquired, after the dam was shut, after the lake came up, that the state somehow has a claim to it, which is offensive and constitutionally impermissible.
Okay, but there hasn't been any after flooding, like I said, Devil's Lake is done by natural causes. There hasn't been any of that since the decisions were made back in the 50s, has there?
Yeah, well, there's a separate decision involving Devil's Lake. I think it's back in 1988. I want to reiterate Devil's Lake case. I don't have the case in front of me, but Devil's Lake is kind of its own different monster, just because Devil's Lake is a naturally occurring lake. It wasn't man-made.
Right.
And that's the distinction with Sakakawea. Lake Sakakawea never existed back when North Dakota became a state in 1889. And when we talk about the equal footing doctrine and what the state of North Dakota acquired when it entered the Union was the right to all navigable waters and the land under all navigable waters. That's why we look at the historic Missouri River, because Lake Sakakawea quite obviously didn't exist at statehood. So even though when you think navigability, we're not talking navigability in the sense that, okay, I can drive a boat on it today, I can fish on it. The issue of navigability with regards to this mineral ownership here is determined at the time of statehood. And since Lake Sakakawea did not exist at statehood, North Dakota has no right to the minerals under the equal footing doctrine. What they have a right to is the right to the minerals under the historic Missouri River, which was determined back when the Corps acquired the property. And I can tell you that the state of North Dakota, back in August 2008, when the Corps of Engineers was seeking public comments on the master plan for Lake Sakakawea and Garrison Dam, I've got a letter from the state engineer. It's signed by the state engineer and by then Governor Hoeven, that they submitted to the Army Corps of Engineers saying North Dakota's interest under the historic Missouri River is limited to 30,000, that's 30,000 acres, no more, no less. And we produced that at the Supreme Court as part of the record. We put that in at the district court hearing. So North Dakota, by their own admission back, in August of 2007 or 2008, said this is the extent of our ownership. And now what Wenck Associates, with their survey says is, oh, well, now the state owns 10,000 more acres, which, we'll fight that like mad in court.
Totally. Well, and that's where I was going with this, was that it would seem to me, just, being somebody who's casually following this, I'm not as embedded as you are, but because it was a man-made lake, basically, the people that did the surveying back then would have the best information, wouldn't they?
Spot on, brother. That's exactly it, and that's exactly what the United States Department of Interior said in March 2016 when they rejected the state of North Dakota's attempt to redraw the line based on the Bartlett and West survey. And I'd be glad to email that to you, Jason. It's about a 10-page letter, very simple to grasp, very simple to read. You don't, I like to think I'm a pretty sharp legal mind, but you don't need to be, like I said, a constitutional scholar to understand what they're saying. They're saying exactly that. And for the state to say this property had been owned by private individuals, folks like my grandparents, like your grandparents, people that came out here and busted their butt to make a living, to provide for their families. That land had been owned by those families for over 60 years. And now all of a sudden the state thinks that they can claim ownership of it. I told a few newspapers earlier this week that the state of North Dakota is not standing up and fighting for its citizens and private property owners on this. And I'm damn glad to pick up the ball and start that fight, because somebody has to do it. And if that's us as the underdogs, we were underdogs in the Wilkinson case and we won that decision. We were underdogs for Red Lynch and we did pretty well there. So, if there are folks out there that think this is wrong and they've got minerals that are impacted and the state's claiming them, they can give me a call, because we'll start a fight and we'll bring some lawsuits.
Well, it's state-sponsored theft at the end of the day. That's really what it is, because they're taking away something from someone who it's legally theirs, and they have the power to go hire whoever they want, pay them, and get the results that they want, and then adopt them. I mean, that's right. That to me is what I meant earlier by that. Just seems the new quid pro quo for government now. And the reason I brought up Devil's Lake, and by the way, Josh Swanson Vogel Law Firm, we'll wrap it up here in just a second, but I interviewed a gal a number of years ago. It's probably 7 years ago, and so I don't know if it's changed since then, but how Devil's Lake has been coming back. I mean, a lot more land has been flooded because of the natural, whatever you want to call it, the natural coming back of the lake. I mean, a town got swallowed up by water, for crying out loud. So the interesting part of all that is that those landowners still have to pay taxes. Yep. And so I find it funny that on one side of the state is using all this money and resources to go do a land grab and try to or a mineral grab to try to get some money and take away a good income from North Dakota citizens. Where on the other side of the state, they're ignoring the fact that you've got waterways and right to water deals and whatever that federal government navigable waters things is, where these people have a legal right to say, hey, we should be paying big taxes under this this water that we can't farm on anymore.
Yeah, and it's interesting you bring that up, because I'm being from Maddox, North Dakota. My grandparents are from Devil's Lake. I grew up in Devil's Lake. My grandparents had their retirement lake home right on 6 Mile Bay. And back in 1996, when I was a freshman in high school and the water table there started coming up, they literally had to put their house on the back of a truck and move their retirement home from the shore of 6 Mile Bay into town into Devil's Lake. And now my family, my uncles and my aunts, they have property, a bunch of acres that they're paying taxes on that's under 6 Mile Bay. And in fact, when we go out there in the summers, you can take the fishing boat down the old driveway that went into their yard. You can see the dead evergreens on both sides of the road. You can pull into where the house and the yard used to be, and there's still a light post where the garage was. And on that light post, we'll go out there and we'll notch a mark in the light post every year for where the water line is. So, you know, for the state to be able to make those landowners pay taxes on it around Minnewacan, you're right, Minnewacan was swallowed up by that water, and they had to move the school from the edge, what was the edge of town, to the other side of the highway. They had to build a new school. They didn't even move it. They had to build a new school, and that town, their whole infrastructure has been impacted by the lake. And, you know, I used to tell people when they asked where I was from, I'd say, well, I'm from Maddock, North Dakota. They'd say, where's Maddock? And I said, well, we used to be 40 miles from Devil's Lake. Now we're only 20. So it's, you know, state picking and choosing what benefits them. And, you know, I expect more from our state leaders. We're a small state. We know each other. We know our governor. We know our senators. We know our congressmen. The folks that we send to Bismarck to represent us in the legislature, we know them by sitting down at cafes and bowling alleys and having coffee with them. We see them out at high school football games. You know, we see them out at church on Sundays and potluck dinners and benefits after that. And I really hope those folks are listening and ask the state when the session comes around, what in the heck are you doing? What are you doing? Didn't we fix this last time? Didn't we address this last time? And, you know, like I said, there were some folks that worked awfully hard with the best intentions and with good hearts of trying to fix it, but they just put in that poison pill calling for a new survey. And, you know, like I started, I'll end with what I started. You know, it's deja vu all over again. We had a problem with the initial study done many years ago by Bartlett and West, and now we got a problem, the same problem with the Wenck survey. And so it looks like we'll be bringing the same lawsuit that we brought previously, and we'll go to the Supreme Court, and they can decide it and figure it out. And I hope that they see the constitutional wrongs being done and side with private property owners on this one.